No, I do.
But I have started the recording.
Okay, fair enough, thank you.
I was trying to warn you.
Fair warning.
Yeah.
Yeah.
Yeah, I'm good on my end together whenever.
Yes, so I know we were in the middle of 13 last time we left off.
Yeah.
Actually, we have a department chair here in attendance today, who is gonna speak on behalf of one of our proposals, so
Okay,
I don't wanna waste their time, and so I
Okay.
thought we could put that on the front end.
Sure.
first.
go ahead.
So Jacob is the one who has that article, I wanna send them that.
Okay. That will take a second.
Chairs and out.
You got everyone copied on this one where you canceled on 418?
I think so.
I'm just gonna.
Oh, yeah, actually, can we just
I'm gonna
talk
read
about
that
that
all
real quick?
that. Yeah,
So, even if we can't meet on that day, I think we should still exchange some proposals. There'll probably be some like easy ones to like kind of TA or get out of the way at that time, so.
we'll talk about it. I mean, I don't think any substantive bargaining we're really interested in doing.
No, we don't, we can't do that over email.
Right.
obviously, But I'm saying, even if it's just an exchange of proposals, we can at least get a look at.
Via email?
Yeah, via email.
Okay, we can probably do that, as long as, I would just leave the narrative off. I
Sure.
wouldn't go into like a lot of narrative in the email.
Oh,
It's
yeah,
literally
no.
just,
Yeah, just exchange.
yeah,
And that's when next time we can have a more in-depth discussion about what.
Yeah, and also, like I was saying, like maybe we can just limit it to the ones where it's like we're being close to being done.
yeah, and at that point too, I don't know how many. Like, I was looking at the scorecard, I think at this point, I think you've got all of them set, maybe 3 or 4 today, but you may have, I don't know yet today.
My lab mate and lab manager in my lab were so pissed at me for hawking the printer.
Okay, gotcha.
Do we need this? We can do it,
Well, I got one good.
okay.
Which one are we doing?
It's Article 16.
16, got it, okay.
Is the one under drive the most recent one?
It is, the one on, that has the date of today on the drive.
I can do it.
He
Okay.
doesn't deserve it.
All right, so jumping to 16.4,
Uh-huh.
we've reverted back to the RT language you had proposed on December 8th. In other words, we're giving up on our attempt to widen the eligible applicant pool to include those who do not already have a GA appointment with UF. Recognizing you struck the entire article after we added that language, it seems that that was the key objectionable content. So we are conceding that and, reverting back to the language you found acceptable in December. Just want to point out that RT is one of the most standard provisions in university contracts in Florida. Every single GAU chapter has it. In some cases, they phrase it as a FTE, allocated to like supplemental or additional appointments, which was close to like what we were trying to get at with our other provision. But like I said, we're abandoning that. But it is extremely standard across all GAUs. Every faculty union contract that we were able to look at also included it. It is very much in both of our interests, and there's wide agreement about that, which is why it is so standard, and we have department head here to talk about it.
Yeah, and Kathy, if you wanna.
So, yeah, I am Gloria Griffin. I am in the School of Art and Art History. Specifically, I'm the Director of Graduate Studies for Design and Visual Communication. And I know that when Cassie first started describing this position to us, as a faculty member, of course, I immediately thought about how that could lead to developing collaborations between our department, our school, and the GAU, exchanging, community relationships and being able to develop relationships with other entities outside of our own is a really important part of what we do in our program. Our students are very engaged with the co-design process, like designers design inside of communities rather than dropping in from outside and being like, oh, isn't this the thing you wanted? Developing a relationship over a longer and more sustained period of time. And I can see how that would benefit not just design students, but really any kind of graduate student who ended up in this release time position. I think I was excited to support Cassie's application for such a position because I see and understand on an almost daily basis how Cassie brings her interest in human rights and labor rights and union rights to all of the work that she is doing as a designer. And I immediately got very excited the possibility of her being able to develop a more formal collaboration and long-term relationships between design and labor rights and union rights in this way. And I can only imagine that other directors of graduate studies would be equally eager for their students to be able to participate in this program. I think for us, we were excited also about to be quite honest, the additional resources, right? Like being able to collaborate with Cassie and know that her tuition is being funded, through the work that she is doing here, would be an amazing and excellent thing from my point of view as a director of graduate studies. But mostly I just wanted to turn up and support Cassie and also support the general idea because I think it's an amazing opportunity for students long term and having it codified and recognized is also the opportunity we can use. So I'm happy to do questions, but mostly I just turned up because I was so excited about supporting this opportunity both in the short term capacity and in the long term with other people in other departments.
So, questions for all of them? Thank you so much.
Thank you.
And I just want to reiterate one point that, I mean, last time when you presented your proposal, you said essentially that this doesn't serve the university's interest and only serves our college, as a unit. And, while it does serve our interests as a unit, it also serves the university's interest, not just, from the departmental, level, but also from the administrative level there, deal with, have someone who can grievances and other type of, non-organized related, functioning, general everyday functioning. Which benefits, university administration. So, yeah, thank you for speaking.
Yeah, thank you for giving me time and thank you for squeezing me in at the front.
Sure.
I appreciate it. and
No
I-
problem. No problem.
Continuing on then with 16, on 16.5, there was a question of parking. And, last time you mentioned you don't, think you can support assigning parking passes to GAU. You say you don't believe that's something that's offered to just about any other employee or employee group. And you don't think you're gonna be interested in doing that. So we wanted to listen to that and meet you there too. I'm going to share my screen. As you can see, we have reworked it.
I have it.
Yeah, this is gonna be something else, but we have reworked it to designate a single parking spot for use by UFF GAU personnel in the parking lot of the building where our office is located. So to show a little context there, our office is in Yon, and by Yon, we have all these parking spots here.
Mhm.
And in each case, they are designated towards specific people.
Right.
A good amount is for UF Rec, but there is the video department. There's one in which the sign has been removed. I'm not sure if that is still designated towards anyone, but it previously was clearly. There's ones that are designated towards specific license plates and these GEMRU parking. And now that is on the first floor of Yon, going then down to the ground floor or kind of a basement level. There is parking inside all those pillar structures, and those are all reserved for the College of Health and Human Performance. So up top, I mean, down below, we have across all of this, and then a little further down, all of these parking spots. There's 20 parking spots available. And up top there, by my count, was 11. And just want to point out, by providing an office space without nearby parking, we accumulate parking tickets and risk being towed to transport any big item in and out of our office space. We asked for the parking passes, so there's an orange lot. If you were looking at this picture, like standing where this picture was taken, and you looked over to the left here, there's an orange parking lot with, I would guess, 50 to 100 parking spots. And I figured that that would be a smaller ask, to just ask for parking passes to the further away lot with more parking. But if you're worried about that being unprecedented, there's certainly precedent to allocating parking spots right here or down below. And that could be a good solution as well. So I tried to respond to the concern you raised last time and adjust the ask.
Did we have any questions about that? Okay, thank you.
I believe that is all. The remaining parts that are edited were wording that you had accepted, even in the most recent proposal where RT was stressed in the parking.
So I mean, we went back and forth on 16.7. You guys are now okay with that?
Oh, that was an oversight. Sorry.
I'm not trying to tell you to say no, but.
No, that was an oversight. Since we were reverting to old language, I pulled the
I
wrong.
just want to be transparent about the fact that it would be a difference of your position from where you had been.
Yes,
previously.
please,
Okay.
let's strike or as soon as practicable, as it was in the proposal you made about a week or two ago.
All right.
I also restored the memorandum. Now that we know what that was.
What's that?
We had asked what that memorandum thing was, and you explained it, so I put it back.
Oh, gotcha. All right,
So yeah, if you wanna go back to the Article 13, your proposal.
okay, we can do that.
Yeah, it might just be best just to start over because it was right at the end and I was
Yeah.
trying to back up, so
All right, so I mean, I didn't make like 8 copies again. Hopefully,
No, no,
most of you guys have them.
I have mine.
Okay, do you guys have, I don't know if you want here, but I have them. You
It
guys are
should
good?
be
or
in
do
the
you need
drive.
one?
Did you hear? Oh, I guess
I made
you
4
got it.
copies. This is 13. Robert, do you have yours or do you need one? Okay. You guys all have?
Yeah.
You weren't here, so can't read one, right?
I was here, but it's fine. I'm looking at.
Okay. Austin, do you remember where we kind of were?
I don't, so let's just, I think just start at the top
Okay.
and pretend like we've never seen this before and
Okay, fair
have
enough.
discussion.
Okay, so I think 13.1, our attempt was to standardize, what we have across multiple bargaining units
Mhm.
and across multiple employee groups. As opposed to, and I recognize one of the discussions we had on this last time is that, well, you already have differences. And while I think we're willing to acknowledge we do have differences, I think we are working to eliminate those differences between different groups. So, I mean, this is our attempt to say, look, we realize this is a very important issue. What we don't want to do is create different standards or extremely close but different standards between different contracts and between different groups. So, you can see that the language there is our attempt to standardize it, with what we already have. I didn't put the reference in, but you have to remember, which, that's right from the reg, that list is right from the reg, is it not?
1.006.
1.006, thank you, I should have put that in the notes.
Sorry, which one? What are you talking
1.006,
about? No, but.
We're on
which
13.1.
part?
Just
Like
we're
the-
starting at the top, yeah.
Blue part.
Yeah.
Correct.
correct.
Yeah.
So that,
And I think
And the
our
name of that
state,
regulation is what? Or
It's
number?
the 1.006.
yes,
yeah, and I think we can appreciate the, that you guys have an attempt to standardize this. I don't think, that we really agree with that standpoint. I think from the point of having a CBA with our union, we're focused on protections for our members.
Mhm.
And I think we're gonna continue to fight for the maximum of those protections, even if that means being different than the UF regulations, which we view as a minimum in some cases, and doesn't include a lot of the cases that we had before, but we'll definitely take a second look at that and see what we're going on. For the word solely in line 15.
Yeah.
Was that also an attempt to standardize?
I'll tell you, that one is not so much standardized, although I think that's part of it. I believe that what the intent, I believe the intent was to really sort of hem in a new standard for every single personnel decision, meaning if we make a personnel decision that is not tied directly to job criteria or performance, it would therefore be interpreted as discriminatory. And I think that's what that statement actually says.
Well, this sentence in the word solely specifically is taken from the existing UFF CBA, right? So as a lot of this is, and I'll be honest with you, that's where a lot of this is. So I don't think it's not creating that new standard. It's a standard that the University of Florida is already following for the faculty. So
But not for you all.
not for us, no, but I mean, we often look to UF as or UFF as things to look forward and improvements to make. And we think if UF can do it for one group, it's not out of the question to ask it for a second group. And I think that's why we include that in there, and we'll probably keep it in there for our next counter proposals we're going forward.
Okay.
Yeah, so 13.2.
Yeah, okay, so we're
Yeah,
done
yeah.
there.
Yeah,
So I think, this is gonna pertain to the language all the way down through from 13.2 all the way down through 13.3.
Mhm.
Which we've stricken, and we appreciate that, you know, you guys have researched other CBAs and found them. I think you actually, the notes in here, not mine, the notes in here are actually yours.
yes, a lot of those are from where I was pulling
Right,
these from,
from
yeah.
UCA and from UMass.
Mhm.
I can just tell you, I don't think we are interested in expanding into these topics and putting these topics in our CBA. We're not interested in further expanding the specific provisions regarding unlawful discrimination in the CBA. We would much rather, again, and I know you heard me say this on 13.1, we would much rather refer to and depend on the regulations of the university as opposed to having to bargain these individually as well.
Yeah, and I think again, I mean, the point of our CBA is that, and having a discrimination article in the first place is that it's different from the UF regulations. UF has regulations against discrimination. Us having this is additional protections for our members and additional rights. And so these are things that we do think are necessary to make sure our members are treated equally in all of these sorts of standards. For the second half of 13.2, the second paragraph here, and what's the reasoning for getting rid of that? Because that's not changing anything in terms of how things are regulated. That is just an additional source of information for us in terms of existing wages and things like that.
So I think there's already a considerable amount of statistical information that's already available, and I don't think we're interested in creating another report just for GAU. I mean, there is a significant number of reports that we have to make public and available online that we have to report to multiple agencies.
Mhm.
And I think that, I mean, I didn't know many of them are publicly posted, are they, huh? I mean, our Title IX report is publicly posted. Is the EEOC or OEDO report publicly posted annually?
I don't know if they are or not, but they're.
You know, I think that might be something.
What,
we really
what
consider.
report would pertain to the language here?
The EEO one report would include some of this.
What is the deal?
It's as a federal contractor report that we're required to provide. It's called EEO one report, and we have an office that compiles the statistics related to, I can't remember exactly which classes it is. It might be race and gender. I'm not sure which other ones are included, but
And so, I mean, you guys crossed out all of this proposal. And you're saying that there is already regulation, but, I don't see where you indicated this regulation applies all of the topics.
Well, the reporting topic doesn't apply to rate. There's not a regulation that makes. it
Okay,
give
but
you a
say
report
that
right
the
now.
sexual harassment. Like where am I supposed to go and verify that?
Well, there's an entire website dedicated to how we handle Title IX. I mean, there's a well-established process and procedure for sexual harassment. And
well, are we on that? I
Well,
thought we were on 3.2 paragraph 2.
We are in.
Okay.
Yeah, I
We
mean,
just said in general.
Said, like, I mean, you know, it'd be nice if you could provide us with the information that informs your reasoning here, you know, because we're just going on what we've done here, which is this process as is now. If you're saying that the reason for that is that there's already, you know, relevant, regulations related to that, I would appreciate,
So on 13.2, I mean, I can give you the we can find and provide with you the regulatory reference
I'd appreciate.
or where we feel that's covered. 13.2.
Anything else on 13.2?
Yeah, I think, I will definitely look at what the reports you have, and if you can point us towards some of those, we'd appreciate that as well, besides the EEO one report. I think in addition, are asking for these statistics here are because what I've learned by looking at a lot of especially the wages that are given out to us, by GA, that there's a very big difference by department and by these kind of finer metrics. And so we would want to make sure that, you know, not only overall as university sort of following its basis here, but that different departments are not, because we've had problems before where certain departments only pay the minimum, or as in the latest report, we found many that were under the minimum for this latest raise, right? And those are mostly on a department by department basis. So
What
I think
departments
we're
are under
asking,
the minimum.
we sent this to you through the grievance team. That
Yeah,
was-
I mean,
Yeah,
we've resolved all that.
We've resolved all that, yeah, but they were by department, the different reporting is different, and so some of those were just reported differently. So I think this ask for a by department is to help us alleviate any concern if any specific department are taking steps that are against these regulations, which is why we put it by department as opposed to the generic. I assume the EEO one is more of a university-wide kind of system. That's the distinction I'm drawing between those two, is kind of the scale of the data.
Just to add something to consider about.
Yeah.
All this is, information you're asking for requires someone to identify in their onboarding paperwork or through the human resources file their gender, their race, ethnicity.
Mhm.
There's no requirement that you do so. So you may think there's this treasure chest of data that's going to show you this, and that. But you look at your own file, which I haven't done, you may not even identify. So it may not be information that is actually going to be anything beneficial to you, because we can't force you to do so.
Yeah,
It's just something to just take into consideration.
yeah, and I understand there may be those.
Data that may not be at all helpful to what you're looking to do.
Yeah, and that's one of those things where we don't know what information you guys have or what those limitations are, right? So I put in here a couple of different statuses. But you know, we're not asking for a lot of very specific things. I understand there might be some limitations on what people report. But we also know that the university has to report a lot of their statistics already, which is why I kind of included these base ones.
And some of this is not made up. like, I think the federal government, they used to do a lot of affirmative action planning. Because when we make these reports, they give the employer a lot of discretion to, if not identified, then it automatically defaults to this,
Mm.
right? So the numbers aren't necessarily going to be the true picture of what the community represents.
Because of the self-reporting.
Yeah, so if you don't identify that, it defaults to white, I think. Or they say you could determine based on your observations, like which I would never do, right? Or someone has a particularly, say like a thick last name, like I should make an assumption that they are this. No, we're not gonna do that, but the government allows for some leeway for employers to make that determination, so it's just something that is not perfect.
Okay, for 13.3, I think we would like to talk about this separately from 13.2. I know
Yeah.
it's the same end result from you, is it's all been eliminated. And what was your reasoning behind this?
Because, again, this is part of our facilities and operating our facilities, and we believe that, you know, it's a management right to operate our facilities, they're in, and we're not interested in bargaining.
Okay, yeah, I mean, we've looked at this a lot, and obviously this is half of our fight to try to correct what we view as a very discriminatory bill. And we understand that the university has to follow certain regulations in regards to that. And I think, you know, I'm not sure how to word this properly.
I think we should, regroup and decide that because unless they clarify.
There's not really clarifying now. We can regroup. Okay, we can move on to 13.4 then.
Okay. So. Yeah, I think we believe that less is more. We're not interested in a separate definition of sexual harassment in your CBA than we have in, again, maybe the last phrase that we have that we had written by university regulation and policies and relevant state and federal laws. There's a significant amount of work that has gone into sort of reforming and adjusting and editing the Title IX processes and procedures based on guidance that came under the previous administration. I think we're still waiting for some additional guidance to come out of this administration. And for then us to immediately have to go back and go to the bargaining table to bargain the impact of that or to rebargain it with you all is just not something we're interested in engaging in.
Yeah, and I would add that, so I talked to our Title IX people again yesterday, just to get an update on where the Title IX regulations stand. They think people are saying March 29 potentially would be the very earliest, probably not till April. So those are gonna be new federal Title IX regulations, which we anticipate having a broader definition of sexual harassment. It's going to encompass a lot more potential acts of misconduct. And would also have kind of different types of due process and requirements in place. So when we think about sexual harassment and how it occurs, it can occur between student and faculty member, it could occur between two GAs, GA and a faculty member, GA and a student. And so practically speaking, when we're investigating sexual harassment claims, it is beneficial to everybody involved to be working from a uniform set of definitions, because then if we have a broader definition of sexual harassment for a GA, then what is defined for a faculty member or for a student or for a staff member, it creates a lot of problems in terms of enforcement and investigating like what has or hasn't happened and whether or not it constitutes sexual conduct. So from a university's perspective, we're really trying to create a little bit of a lot more consistency here, because Title IX and sexual harassment is really a compliance issue. I'm not sure if y'all just thought, Liberty University just got fined like $14 million for failures in its Title IX and Clery Act areas. So this is something that a lot of universities are focusing on, and it is something that University Board is focusing on as well. So with that in mind, our goal is to, I know you're saying you want your CBA to create greater rights than, what regulations provide, but I think it's really to the benefit of everybody at the university, because sexual harassment can cross different types of employees and students and people who, visitors, anybody who comes onto our campus, to have everybody working from the same policy in terms of definitions of what is sexual harassment. Which is why we're removing the language of what's defined as sexual, what's defined as sexual harassment here. And then the, processes, a lot of those are set forth in the Title IX regulations, and the Title IX regulations actually, I think, may create even more due process rights than even like what might already be proposed in this article. So that's where this is coming from. It's part of, you know, I think something that's gonna be beneficial to every member of our institution to have some uniformity there.
One response to that, if regulations and law define something as sexual harassment that isn't protected by our CBA, it remains regarded as sexual harassment by the university. It's obligated to follow that law and regulation. So us getting a definition that is specific about what sexual harassment involves or is defined as in our CBA doesn't have any danger of us not being protected by changes in the law.
But what if your definition is different than what's in the university's policy or regulation? I mean, like,
We
there's
would
like,
have to honor the contract if it was more like, if it classified something as sexual harassment that the law did not. The contract would obligate UF to regard that as sexual harassment.
do you have
and if the
reason to
law-
believe that this is broader than what the law requires?
And if the law classified something as sexual harassment that our contract did not, the university would still have to treat that as sexual harassment because you're bound by both.
But I'm saying like this particular definition, which I think you just copied out of the UFF bargaining agreement, right?
I'm with slight modifications here.
Have you looked at it and compared it to like what Title IX requires and doesn't require? Because I just think that there's just like little nuances and differences that it's hard to explain and I mean, this is like a world that I've been living in and I work in and on a day-to-day basis. So I'm like trying to, practically speaking, you really want consistency in terms of what is considered sexual harassment. And the way that we investigate it and think about it so that our investigators aren't having to consider 12 different policies when they're looking at whether or not somebody, like if there's a faculty member who's accused of sexually harassing a GA, are we looking at the faculty member's CBA for how sexual harassment is defined, or are we looking at the CBA for the graduate assistants for how sexual harassment is defined?
So what is the current procedure? Because right now, that's in the UFF contract, and it does deviate from Title IX and all these kinds of.
But it's generally consistent with what the university's policy is. So we have a university policy that has broader regulations, and then we have a Title IX. So like when something comes in, we determine whether or not it falls under Title IX, which right now is a narrow definition, or whether it falls under the university's broader definition. And then we're also looking at the UFF CBA definition,
Right,
and it's challenging.
okay.
So I'm saying like, if we want to make sure our investigators are doing a good job and they're capturing everything that could potentially be sexual misconduct, it is beneficial to everybody to have a standard set of definitions.
Right, and so could you like maybe tell us like a little more about what are the challenges exactly, like specifically, like what does that mean in terms of like the outcomes for like the people involved? Having these three done, or is it just like you don't want to read the three?
Well, it's just, I think I've already said it. It's just challenging. You're trying to apply you're looking at one thing that happened and applying 3 or 4 different definitions.
So like, okay,
And so for the
has there
person,
been a
so
situation?
for the person who's, and I'm not gonna get into, I don't want to talk about it in individual investigations,
Sure,
so I'm not going to do that. But for the person who's being investigated, oftentimes that's confusing and challenging as well.
Sure.
Because they're like, well, what am I violating this? Or am I violating that? Or am I violating this or violating that? This is like why it's better to have a standardized set
So
of,
has there
what
been
is
cases
considered?
where someone is violating one set of rules and not another set of rules, and they've either gotten out of trouble or gotten into trouble as a result of it?
probably. I mean, I can't say for sure. I mean, I have to go through every single report and, you know, figure out like, what the analysis was. I'm just, this isn't meant to be, you know, I think there's an impression that every time we remove language, it's because you think that we're like, like, this is actually meant to be beneficial for everybody. And the university is currently in the process of waiting for these new Title IX regulations to come out, which, are supposed to be coming soon. And then overhauling and revamping as a university, like university-wide, our policies. And so to now be like, well, everything's different except for the one, the GAU CBA. It's practically speaking, it's better for everybody. It protects, I think, more people's rights to have kind of a consistent set of definitions. And then I think it's until next section, we actually talk about the investigations. There are some things that I think make sense to put in CBA for like providing additional due process for your members. But we're really, in terms of, procedurally how these cases are handled, we really have to follow what Title IX tells us we have to do. Or that's like where you get into these like compliance, kind of matters and issues.
You said that you think it's gonna protect more people if we standardize things. But that contradicts what I said last, which is that Title IX, anything that Title IX labels as sexual harassment cannot be violated. You are obligated to like protect against those types. So if there's ever an instance where GAU is not providing a protection, our CBA, that rather, is not providing a protection that Title IX already protects, that doesn't limit people being protected, because UF policy must conform with Title IX regardless of what's in our CBA. The only thing that could happen is our CBA in some instances could label more things as sexual harassment than Title IX. And so to take that's just like factual. That implies that if we were to surrender language, we are surrendering the possibility that we could protect against more things, to have a wider umbrella of sexual harassment than reverting just the law. And
I understand what you're saying, but right now, this definition of sexual harassment, we don't know what the new definition of sexual harassment is going to be in the Title IX regulations. So until we know that definition, we can't we can't say that this is or isn't broader than what Title IX says. So if we get the new regulations, they come out and you read them and review them and make you understand them. Because believe me, lots of regulations that came out were just crazy. So hopefully these will be, you can all understand this a bit better. But you read them, review them, and you say, we think that we think we want our CBA to cover these acts that aren't already covered by Title IX, then that is something that I would consider and think about. But right now, the way this definition, I haven't been given any, there's nothing telling me that this is or isn't broader than what Title IX covers. So, and until we know the new Title IX regulation, we can't, what you're saying, we can't, I need to know, we could repeat the Title IX regulation definition in here, and then you could add things to it, and that would make sense with what you're saying. But right now, I think this definition is kind of a mishmash of what Title IX protects and otherwise. So that's why I'm saying it's a little bit premature.
Yeah, I think the result is we're not gonna find progress or a solution to this until we get those new Title IX regulations, which is what we've been saying for a couple of
Yeah,
months now.
I just
So
wanted all to know where I'm coming from on this. Like,
I
it's
understand.
not, I'm not just trying to like take your definition out. Like this is the world I've been living in for 3 years, and I can't wait for the new regulations to come out. And I just want you to know it's coming from a good place.
Can you hear me?
we can hear you,
Yeah,
Brandon.
go ahead.
Yeah.
We're move on, but you want to say something real quick?
Yeah, I just wanted to add to this where we're coming from for this as well. It's important to note that we don't when university changes like regulations or policies or anything like that regarding any of this, we don't have a say. So it's important to also have some of this language reflected in our CBA. So it's something that is we can, that we actually bargain for and talk with UF about versus just one day having a regulation change that we may not agree with, but we can't really do anything about because it's not in our, not protected in our contract.
I think that's a really relevant point, Brandon. Because we view it exactly oppositely, and let me explain why. If there's a federal regulation that we have to abide by, we're gonna abide by it. And we do not want to be drawn into having to have a big argument with GAU about, even if you acknowledge, hey, we realize that's a federal regulation that you guys are gonna comply with, but you're still gonna come to the table and we're gonna bargain it anyway. There's already protections in the contract that say that if we have to impact the provision based on complying with the law, then we have to participate in that meaningfully with you. If we change that and go farther and actually include some of that stuff substantively in the contract, it creates a much more difficult situation in which you're gonna be frustrated with us because we're gonna be like, look, we're complying with this. And you're gonna say, well, now you've unilaterally impacted the contract, not just in terms of the severability clause, but now you've gone beyond that and you've actually changed entire definitions. You've changed. It's not because we want to unilaterally change the contract. It's because we know we have these constraints to which we're going to comply. And the threat of having to be at odds with you or at odds with a federal or state government, we're going to comply with what they tell us. And unfortunately, we're going to be at odds with you. And that's unfortunate, but that's how it's going to roll.
The way you're using the word comply doesn't mean what I would use the word comply. So for example, say we kept some of this language, we scroll up a little bit.
How far us?
Right there, or wait, one more. Okay, so, for example, it's defined as unwelcome sexual advances, requests for sexual favors, or verbal, digital, or physical contact of a sexual nature when blah, blah, blah. Total hypothetical, but say Title IX didn't mention digital. And so in our CBA, now we're broader than Title IX because we've defined digital sexual or physical or digital conduct of a sexual nature as possibly sexual harassment, right? Complying with the law doesn't mean I cannot regard digital contact as sexual. It means I must regard what if called sexual harassment as sexual harassment. And because of this other contract over here, I must also, when I set my university policy, consider digital part of sexual harassment. So it's not a matter of compliance. It's not like when Title IX comes out, we have to impact bargain and strike digital out of it so that our contract literally has the same text as Title IX. That's not compliance. That's trying to like impose uniformity with what you're required to bargain with one group and what somebody else over there told you to do. That's not the same thing as compliance. That's not how I would use the word compliance. Compliance would be like Title IX says, only this can be considered sexual harassment. And if it happens in the digital realm, it's not sexual harassment. Again, this whole hypothetical.
I think you made your point, like, you can respond and I think really need to move on because we have like a lot of articles.
Gotcha. I mean, I think what I would say is that for that hypothetical, what if it were reversed? I mean, I think there's some pretty difficult situations, meaning what if there was a modality that it included in the compliance regulations that you didn't include?
Yeah.
And now let's say that both parties in a given event were both members of GAU. Not that I mean, let's just say that happens. So now you're in a situation where one of the members wants to use the definition that's more beneficial that's in the CBA, and the complainant wants to use the definition that's more beneficial that's actually in the UF reg.
And they have to follow the law. You and I both know that. They can't violate the law just because a contract with UF didn't say it's against UF's contract with you to do this form of sexual harassment. The law said it's against the law to do this form of sexual harassment, and they can't claim an independent contract supersedes the federal law.
Well, I appreciate that, but I think we've had other conversations about other articles where I think we share an interest in trying to make the provisions clear. I mean, we have specific sentences where you're like, we really want to have this sentence just for clarity, even though we acknowledge it doesn't have anything. Can you imagine being the subject of an investigation where you're looking at your contract and you're in a situation to represent someone who would say, well, we understand that our contract defines it this way, but you're not actually protected because you violated this over here. Like, I think there is a possibility that's not that it's not that difficult to understand where it could be extremely confusing for either the complainant or the respondent in a given situation to try to navigate that if they're in it, let alone the legal team that's experienced with those matters. I mean, if you're actually in the situation as either one of those parties or maybe a witness, if the amount of confusion that I think is possible is not, it's not negligible.
Okay,
We can move.
yeah,
Okay.
I think we need to discuss it.
Okay, so.
Did you just want to be
13.4.
done with all 13?
No, no.
Yeah,
Oh,
let's
okay.
keep going, but we'll just try to speed it up a little bit.
Okay.
I assume a lot of the reasonings in the future, especially in regards to the disciplinary action is stuff we've already discussed
It
a
is.
little bit. So we can just go through 13.4, just move a little bit quicker
Okay.
here.
So 13.4, and I believe, much of this is in response to, some of the I can't remember who proposed the initial language. I think it was actually you all who may have brought this provision at first. So we provided some clarifications. The university and GAU recognize that sexual relationships between GA students and faculty when consensual may become exploitive, and especially so when a student's academic work, residential life, or athletic endeavors are supervised or evaluated by a faculty member or a GA. So the first one is a very specific sort of prohibition. There shall be no sexual romantic relationships between GAs and other employees where both parties are affiliated with the same degree, program, or department, and under any circumstance in which the employee exercises academic evaluative or supervisory authority over the other, or may be reasonably expected to do so in the foreseeable future. The policy does not apply to sexual romantic relationships that existed before one or both parties' arrival at the university. I think the next one is very similar to that one. I'm not going to sort of read it out unless you have a question.
Well, I think what we did was we felt like what was missing was something about undergraduates.
Yeah,
Mhm.
for sure.
You're trying to think about the different relationships that could occur. So the first one, it's like a GA and any other employee.
Mhm.
It said faculty members, but it seemed like it should include other.
It should include, yeah, and I
Yeah.
appreciate a lot of the changes you guys made here have been to broaden it and make it more clear, and I appreciate
Yeah,
that,
and then
because
so-
obviously that was an oversight. We
Right.
wanted to include the same
Because I
thing.
think you pulled this from the faculty one, and so theirs is a little bit,
There's some changes that need to
Yeah.
be made to
And so-
represent that.
yeah, so then we put in the undergraduate, but not two with for the undergraduates.
Right.
And then I think three was again, I think we added the undergraduate language, I think.
Right.
And then just noted that it
Yeah.
changed it from faculty member, yeah.
Right, because the relationship between a faculty member and an undergrad, or a faculty member and a grad student, is not exactly the same as the relationship between a grad student and an undergrad. There is nuance.
Yeah, and what was the reasoning for getting rid of the first
Oh, my
two?
battery's about to die.
Okay, what was the reasoning for getting rid of the first two clauses here in 13.4? Well, once again, that is from UFF. For those definitions of, what sexual harassment is, that just for the same reasons we
In
discussed?
line 72.
Yeah, is that just for the same reasons we already just,
I
I don't want to get into the weeds here, but,
Yeah.
okay, I just wanted to clarify that.
Yeah.
I don't want to get into the weeds.
And I will say 90 and 91, I deleted because I didn't want anybody to think that they would have to report a consensual relationship and a conflict of interest. And like, so because we kind of use the term conflict of interest, I just like, I don't want people submitting like eFolio forms because they're having a consensual relationship. So, and there does talk in here about
Yeah, I thought you were supervisor.
calling your supervisor. So I felt like that was probably.
It's covered, yeah,
Yeah.
in a different term. And then, 125 through 127. That was removed as well.
Policies and regulations regarding harassment shall be employed to protect individuals from discrimination, not to regulate the content of speech or restrict the academic freedom and free speech rights of GAs. I'll be honest, I think with regard to that one.
Okay.
Again, I think the relevant policies and regulations should stand on their own. I mean, if I think a policy or regulation is being misused or misapplied, I don't think we have to necessarily call that out specifically. I mean, that's the purpose of the policy or regulation.
Okay, 13.5 then.
All right, so we had a lot of conversation about, whether or not we were getting dangerously close to turning GAs into mandatory reporters. So I don't know, Olivia, if you want to talk about that a little more broadly.
I don't want to speak out of turn. I think there just might be some discussion university-wide about who is or isn't going to be the mandatory reporter. And so I think until there's a little bit more clarity on that, I just don't want GAs to have a responsibility. And that it could potentially put a lot of kind of compliance responsibility on GAs.
Yeah, and we tried to make
I
it
don't know.
specific where there had to be a power differential and have that direct observation, but I mean,
Yeah.
I'm not very familiar with the eliminated reporter and what that means in a legal sense and
It
stuff
can
like
have,
that.
it can have criminal implications.
Yeah.
It's in favor
Yeah.
of people reporting anything and everything, so like, I didn't wanna take this out, because it's not like I don't want people. I don't want people to not report,
Mhm.
it's just, we can maybe think about it some more about what that appropriate language should potentially be.
Yeah, and maybe there's just a better way of wording that
Yeah.
where it's encouraging people to. do
Yeah,
what they
yeah,
should
I
do.
mean, please report
Yeah.
anything and everything.
Okay, moving forward, were there any major changes in the rest of?
So, 137, I crossed out formal, just because there's a kind of distinction between formal and informal complaints in the Title IX process, and I didn't want GAs to think that, they could only file a formal complaint, so you can file an informal complaint without having to go through a formal investigation, and I just didn't want that to be kind of viewed as a restriction on what they could have complained about.
Okay.
I think I tried to kind of clean up the retaliation language a little bit to kind of include. I don't know, just a little bit confusing the way it was written, so I just tried to clean it up.
And that again is from UFF, so
Yeah.
it's not something I'm very familiar with, so I felt the best case would be to take that direct language to match that.
Yeah.
But I mean, if the intent is, it pretty much is the same thing with like, just to clear it up and make it very similar,
Yeah,
then
it
that's fine.
doesn't really change what it says, or,
Yeah.
retaliation is.
Yeah,
I think we added that, or maybe I moved around some language about that if employees being investigated, that they can have a GAU representative or legal counsel present at any interviews, and that a copy of the report shall be sent to UFF GAU president.
Mhm.
I think that may have been somewhere else, and I just moved it up into that paragraph.
okay. Then we get to the disciplinary action, and I assume that's for reasons we've already really discussed.
Yeah.
So I don't want to spend any time on that, since you spent a lot of time on this, but we can just move towards 13.6. It's on the back page, 226 or 28.
All right, they shall have the right to inspect and have a document anything discrimination or harassment, made against them.
What line?
228,
228.
on the very last page.
I think I just added-
That are exempt.
Yeah, I just kind of added that to, if the documents are confidential under law, like if there's some kind of. It's just. If they're public records or they're confidential, then obviously there might be limitations, but. Someone's allowed to look at.
Yeah, and then we have changed from groups they're a party of to made against them. And 229. So that's a limitation, right? Because it's just, they can access these when they're made against them, but not.
I mean, it wasn't, I guess I didn't. I don't know.
That would pop out.
I don't
And that
remember
would come
which-
out in the procedure.
I don't know if that color is our color.
Red is you guys crossing out, so like, I'm just following that red, so I think that's you, but.
I'll make it right.
Yeah. I mean, I obviously don't think I have an issue if you're the complainant looking at the documents,
Yeah, and that language again is
Yeah.
from UFF because it makes sense to have it as long as you're one of the major parties.
Yeah,
And,
like a witness would complain too.
Yeah. Okay,
So complainant, respondent.
yeah, they're limited to those two main, we don't want just anyone having access, obviously.
All right, so 13.7, let's see, like lines, I added 235 and to 237. And this is something that we have, this is because it comes from experience. So if a grievance is filed, so if somebody files a grievance related to discrimination or harassment, sometimes what will happen is they'll file a complaint with Title IX. And that's going through the Title IX process and it's being investigated. And then they'll also file a grievance. And then the grievance is complaining that, an Article 13 is violated. And then when it goes to the hearing officer, often you don't want the hearing officer essentially conducting the investigation of whether or not there was discrimination or harassment, because they're not a professional investigator. We have a whole group of people who do that. So essentially, this is saying if a grievance for violation of discrimination is filed, while an investigation is pending, the grievance process will be told until the issuance of the final investigation report. So it's just to prevent essentially a hearing officer from conducting kind of like a mini investigation while Title IX is conducting kind of like a full-blown investigation, which affords due process and all the things that, go along with that.
And I'm not familiar with the terminology, it's told just like pauses
Yeah,
the
everybody
grievance
just
process.
pauses,
Okay,
yeah.
just making sure that,
Yeah.
and that makes sense. We don't want, investigators to feel rushed either for a grievance process.
Right, yeah,
So
and
that-
there's more due process rights that are afforded through the investigation process than there would be through just like a grievance hearing, so. And then this is the same language, I just reworded it, that if you file a charge of discrimination with the EPSC or the FCHR or something, then you don't get to also file a grievance for that same issue.
Mhm. Okay, and then we just have the passage of law section, 246 down.
Yeah, so I mean, that concept is already contemplated. I
Oh.
think it's in Article, is it 24? It's already contemplated really in Article 24. So I mean, having a separate sort of severability clause, like if we wouldn't need to adjust that one, I think we would probably not have different severability standards. Like, if something causes us to have to enact a policy, then it should be dealt with there, not here.
Okay, I think that was just an attempt to cover our bases and make sure those parts were specifically protected. I
Right.
think we'll have to discuss and see how we feel about combining those things and see what we feel about that, but I think that's it, unless you guys have any more questions about it.
Okay, we have several articles for you today, but I think we might as well attempt it.
Almost two.
Let's just start with the ones I think that are pretty close to your previous calendar.
Okay.
And then
Great.
if time allows, we can go with more.
All right.
So, Brandon, I think we can start off with 20 and 21. So we want to do 20 first.
Yeah, for what it's worth, Sikander
Mhm.
and your team, when we went back through and looked at everything, we feel like we're probably pretty close on maybe as many as 8 or 9.
I think
Like,
so.
I feel like we're,
Well, I think there's at least 4 that we're presenting today, which I think.
oh, great.
All right, so for Article 20, we felt that for there was language in there before talking about supervisors, and we felt that for violations under 20.3 here, we felt the language of an administrator is more appropriate, than having like a supervisor having discretion on whether to investigate or to investigate them or handle it themselves or things like that. So the language we replaced it with is that the appropriate administrator shall investigate such conditions. We would like an investigation to happen when a condition that could be a safety violation is reported. And instead of like leaving it up to the sole discretion of the administrator whether to investigate or not, which was the proposed language previously, we added in here that if the administrator deems a formal investigation is not warranted, they may request UFFDAU to waive the right to trigger an investigation. So it's more of like we both UF and GAU agrees that an investigation is not warranted, and at that point, then an investigation will not continue if the administrator first deems it that it's not necessary, and we agree. We also added in an extra line about which we noticed was I think this was from partly from OSHA language. For the extent of investigation shall be reflective of the seriousness of the safety violation, which is some more excellent language to explain like how the investigation is from OSHA. We also struck out the good faith report as well. We feel that at the bottom. I know that originally we agreed to striking out reasonable potential violation, but keeping good faith. But after reviewing, like with our grievance team, there really is, we don't know of many instances where a bad faith report like came in, and we feel that the language may be a little too restrictive, and it could cause an argument over whether a report is good faith or not, which we're not really interested in. So, I mean, we feel that that as current contract language regarding the the reasonable and the good faith, like just removing that and keeping CCL is what we're interested in there.
Brandon,
Um,
how do you, oh, sorry, go ahead.
no, that was it. I think the rest of the article was still the same from our previous proposals.
How do you see, sort of the unstated evaluation in line 18 going? Meaning, what are the types of criteria or expertise that the union is gonna use to determine whether or not they would be willing to waive an investigation?
I
Could
think
you,
this would be addressing the good faith aspect of it, right? Like, if it is like totally frivolous,
Or repetitive, you
Yeah.
mentioned repetitive, like you got one complaint that triggers an investigation. Then you get a second one, are you supposed to do a second investigation even though you already did one and know everything? Or you mentioned sometimes you have professional reports about an issue, but it's not legally considered an investigation. It's like your experts think. I imagine you all would be presenting this to GAU and we can be reasonable, like your goal here is about like making sure there's reasonable concerns and we can listen to your reasoning and be like, yeah, that makes sense. We
yeah, I
don't
mean,
need an investigation.
yeah, I mean, it's not like we want like to bring in our own team of manager staff to evaluate the whole case and do like our own like investigation. Like, we're not asking to have like our own investigation. We're simply asking that if the administrator deems that a formal investigation is not warranted and it shouldn't continue, just to let us know that, and just us to make sure like, oh yeah, that's a frivolous, or that it's has already been handled, it's already being investigated, like we don't need another investigation, just like Jacob said. Like, we're not asking to like conduct our own separate investigations to determine to agree with the or disagree with the administrator.
and presumably the administrator would have some reason for doing.
Right.
that
They would
this-
present those reasons,
Would
and
explain
then
that.
yeah. Any other?
Do anyone else have any questions about this? And 27 and 20.8, those are both the same, right, Brandon? I mean, there's those
Yeah,
crossouts
yeah.
are left over from last time.
Yep, that's all the same, and then the outside
Looks-
appointment's still the same. Yep.
Yeah, okay. All right, thank you for that.
And then for Article 21, so the only change was what we discussed about before, was just for notification being both through mail and through email. Everything else is the same, and I think we're ready to TA for 21.
So it's that one word and
Yes, so under 21.3, under an investigation, we have the notification, so where it says please under B here. So or other A. Yeah, A, sorry. Be delivered in person through United States mail using first class postage paid envelope, addressed to the employee's home address and to the employee's official university email. Same thing in 21.4. That exact line for the notification is also and instead of or. That's the only two changes. Everything else is, what we discussed before, and I think we both agree on.
What was the line number again on the second one?
the whole
For
clause is
notification?
45 through 38.
45 to
Yeah.
40, okay.
Yeah, it's under the notification for disciplinary action.
All right, that looks pretty close. I don't think so. I think we're good, right?
Next,
Do Article 8.
Yeah, we can do it, right?
pulling up the.
So yeah, very minor changes on this. I think the other things that changed were in 8.1, we had discussed the being gender neutral, so we corrected mother and father to parent and then brother and sister to sibling. As we had done in previous things, and I believe that's the only change I've made in this. Yeah, so I think that's clear at least. So yeah, it's just those gender terms that we had been discussing before.
But everything from starting in 60 all the way through 91, that should all
Yeah,
be,
that is all stuff
we
we did in
already talked
October,
about,
what you did
yeah.
last time. Yep, none of that is changed. The intent of this is not changed.
okay, so. All right. I think we're close there.
The other one is, 22. And I think we'll have time for my other articles as well, so, we're in good time.
Yeah.
Students pulled up.
So can I have a copy real quick?
Oh, yeah.
Sorry. This one was also minor changes, so. Try to remember, I think it was just the one change, 22.20. It was originally 35, I gave 120 days, you gave 45, and I gave 60 back. Last time you had said you were trying to equate it to, an earlier time date. And the original time date, was 30 and we had 35 here, so this was a longer time than that initial time, so we thought that we should been a little bit higher than the new 45, so we raised it to 60 to compensate. And I want to state as well that that is the maximum that can be given by an arbiter. So that's not the standard or the minimum, that is the maximum they are given. So we think 60 is a very fair number of days to allow as a maximum to for different cases as given by the arbiter. But the intent is nothing else has changed there, I believe, so. And we did agree to, like your other changes in 22.4. You explained that, you thought as soon as practical within 30 days, would work, and we agreed with that kind of logic you gave there, so, we did agree to keeping that language.
All right, so I just want to just check one thing. So I think what we were attempting to do was to link 2220 with 22.9.
Yes,
So the upshot of the proposal, just in sort of calendar terms, would be, it would ostensibly be possible for the arbitrator to reach 15 days prior to the possible time that the university would have even known about the incident. That, I'm not saying that would happen, I'm saying it's possible.
yes,
Okay,
but in the original language, it was still able to go 5 days in the past, so this is raising
Got
it to 15 in the past.
got it.
To account for grievances that may have been longstanding before they came forward and made a formal grievance with it.
It also seems like a really special case, like in this case, an arbitrator would have already said the issue had occurred and be like awarding restitution, right?
It's a limit on how far back from the time you raise your hand that you have a problem. That's what it comes down to. It just, it constrains. Like, you can't raise an issue and be like, hey, this has been going on for 6.5, just an extreme example. This has been going on for 6.5 years.
Right.
I demand that you make it right. And you're like, wait a second.
But the,
You had to tell us, you can't just like keep engaging in this behavior and keep taking it and be like, then you win, like, well, I want 6.5 years of financial consideration. Basically, that can't, that's not how it works.
do you think, I'm asking out of curiosity, do you think the arbitrator like takes that into consideration usually though? That's why I feel like it's more of a special case. So, like,
I don't want to say anything on behalf of what I think arbitrators do. The word arbitrator and arbitrary have the same exact root, and there's a reason.
we still have two 22.24s, so. When you,
22.24.
no, when you fix it, like, the last one could be changed to 22.25.
I forgot to fix that while I was doing this, yeah.
Since you're doing it next, I put it on your radar.
Okay, I mean, I think we're close on that one too.
Yeah, I think that's why we had a lot in our background, and
Yeah.
they were easy stuff, and we were
Yeah.
just like, we had to work on the heavy. And then,
You don't want them on your side of the table anymore.
yeah, we're just gonna get him hopefully done here.
Would you all like to do another one?
Yeah, so Article 9 should be the next one. And I know you guys didn't have, anything to propose for. Oh, wait, actually,
Mine is, I think we proposed this one at CCL, didn't
for 9, yeah.
we? Yeah.
Okay, so yeah, Article 9's article is about academic freedom. I really wish Hannah was here to talk about this because she really comes from a department who is affected by a lot of these issues. So in any case, she definitely put in her input here. And so the first change that we have is just a minor one. It's just that we're saying that academic freedom is defined as the freedom to blah, 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 in the context of this university. That's in the second line of natural one. Then right at the end, we have a phrase here which I've taken just from the faculty contract. This is saying that university recognizes internal and external forces at secret times to restrict academic freedom, and the university shall maintain and encourage, protect, and promote academic freedom. Now for 9.2, which is about academic freedom in the context of assigning teaching responsibilities. We have some minor kind of grammatical stuff at the bottom there, but there's basically three main additions. 9.2a again is language that we've taken from the faculty contract. So in any situation where a DA is primarily responsible for a course or a course section, they have the ability to prohibit disruptive student behavior. And we define various things which are also in the faculty contract. And yeah, essentially any disruptive student behavior that interferes with the DA's ability to effectively communicate with other students in the class.
So Cantor, can I just ask, is this taken over word for word or is there nuance?
I think there might have been a couple of things that I added there, but it's almost entirely.
Okay.
Okay, 9.2b is upon the passage of any university regulation or policy which may infringe on the ability of students to fulfill their assigned teaching duties, the university shall communicate all relevant guidance and information to the FSBAU within 10 days of such regulation or policy. This was something that Hannah suggested. Again, with some of these laws that have gone into effect and then been enjoined, there's been kind of conflicting guidance that GAs received, and yeah, it would be good to have kind of a some guidelines from the university itself about this.
So is this in like, if we decide we want to like stop teaching a course, like can you give
No,
us
like
sort of a
as in like, for
practical-
example, with HB7, right?
Okay.
The law itself prohibits certain topics from.
Okay.
Yeah,
Gotcha.
and so then you would have to have a regulation about that, and in that case, how should GAs deal with that in class?
So,
and-
I'm
yeah.
sorry, so, okay, so this is saying if the university passes a regulation or policy,
Mhm.
so not not HB7, which is a law. So this is a university regulation or policy,
Mhm.
which infringes on the DA's ability to fulfill their assigned duties. The university shall communicate all guidance and information to UFF within, okay, so can you help me understand what you mean by all relevant guidance and information?
Yeah, I mean, essentially, what can you say and cannot, like, what will be the consequences of saying X, Y, Z, and, these are the things that are,
And you're looking for that guidance to be provided to you within 10 days of,
the, kind of implementation of the first regulation. Yeah, I should have specified that.
I'm much more concerned about which implementation of that is.
well, I just wanted to mention.
Sorry, which phrase were you talking about?
I'll leave you to finish your thought and I'll go back.
Yeah, I just wanted to make sure I understood first what you were ideally asking for. Okay.
Does that make sense though? I mean, I think what I'm looking at is there's a big interpretive component of how do you interpret infringe on the ability of GAs to fulfill their assigned teaching duties. I mean, that's a pretty, if the GA may say yes, the university position may be, that's not affecting your teaching duties. You're not, it doesn't matter what the topic is, you're not required to talk about that topic.
Sure.
You think you need to, under whatever you have, your technical ability or academic experience or whatever it is, you're saying, no, I want to talk about this. In that case specifically, maybe you can't or whatever, again, this is all hypothetical.
Say it's part of the course curriculum and then suddenly there's problems that we can't talk about.
Gotcha.
Then that infringes on your ability to teach that part of the curriculum, right? So in those kinds of situations, it would be good to have that.
All right. Okay, I don't have any more questions about that.
No, I mean, I think, yeah, that's, when you initially put this in there, I thought you were kind of thinking along the lines of like COVID, and that was like infringing on your ability to teach, you know, like you actually.
Oh,
infringing your
right.
ability, you know, like, I wasn't
yeah.
thinking like,
Okay.
so
I
thank
see
you
what
for.
you mean.
Yeah, you're
thank you.
talking about something that's more.
I mean, when you said it out loud, I recognize that it sounds a
Yeah,
little
so
bit.
thank you
yeah.
for clarifying what, kind of like what you, how you were, your intent behind it, because
Sure.
I was thinking about it kind of like a practicality kind of thing.
Then 9.2C, this is also something I've taken from another graduate CBA. I don't think it's Florida graduate CBA, but and I can't remember exactly the form it is now. But in any case, CBAs are entitled to freely express their political beliefs and or affiliations. However, they should be careful not to persistently introduce matter unrelated to their subject to their. And then for 9.3, in the context of research duties, every GA is permitted to freely discuss subjects within their expertise, as well as to explore ideas, pursue inquiry, and maintain their opinion and conclusions relevant to those.
Okay. Any more questions, Steve?
When you, and for subparagraph C above, you're saying in the classroom, they're really, you're entitled to freely express your political beliefs and affiliations in the classroom, or just like in general?
This is in the class.
Okay.
But yeah, that's why the second part of the thing. This is not like, you're trying to like get on the soapbox or whatever.
Okay.
but-
Anything else? I don't think so.
So then, 3 articles here. Where,
We've got 40 minutes. We've done what?
yeah, I'm surprised. I didn't think we'd get this. Okay, so Article 28 or whatever, we're calling it 28, you know. So, the first thing is we rejected your deletion, which has to do with basically, you had removed any place where it says regulations and policies, removed and the and policies part. So, I mean, we've just put that back in for now, but I was kind of interested in what the reasoning. behind
Which
that.
lines, Candace?
So for instance, in the title,
Oh,
in
okay.
28.1, and also in line 13, there's another where it says policy versus resolution. So I was just kind of interested in what the reason there was, because again, this language was originally ripped from the contract.
I think some of it has to do with the fact that there's like regulations which are, for lack of a better word, how do you regulate?
Okay.
In terms of how they're developed and how they're distributed and where they're contained. And then there's capital P policies and lowercase p policies. So we have like capital P policies, which apply to like pretty much the university as a whole. And you have, that can be found on the university's policy hub. They're like vetted, they're maintained, they're put up, you know, like they're more regulated. And then there's lowercase p policies, or which kind of like the College of Medicine might have a a policy for, you know, this or that, and then like each department might have a policy.
Yeah.
And so they're a little bit more decentralized and hard to kind of, you know, maintain any kind of control or, you know, oversight. And we're working on, like, you know, one of the reasons the policy have now exists is to try to get all these things in one place. So it was a little bit of, you know, concern about having to be on the hook for like every little policy that might exist out there that, you know, not everybody is, as the university, you know, the university is aware of them, obviously, because there's some administrator who probably read the policy, but in terms of, you know, like making sure that, you know, that any changes to those little policies are, you know, if something happens in a unit that, like, Patrick's not aware of, like, class has some
Right.
little B policy on something and then hasn't communicated the change, like, it's kind of more of like making
I
sure we
get
can comply with this.
So I mean, I think the way that it's written right now, this only applies to university policies, not like policy at any lower level. Yeah, we can
I know,
we
it's-
can make it
no,
capitalize.
it's like- We actually, there is a policy of policies, like, I'm not kidding you, like, there is actually a policy of policies, which is where this is coming from, where I'm like, you know, so
Okay,
it's kind of, yeah, I suppose if it's university wide, it's, you know. it
Yeah,
makes
I
more
mean,
sense than- yeah.
yeah, that's where I was
That's what
coming from. and-
That's where the change, so you asked why that change was made,
Sure.
that's why that change.
That's understandable, yeah. Okay, so basically for A, the first sentence is, was deleted by you guys and I've returned it. Essentially saying the established terms and conditions of employment for bargaining unit members shall not be changed after collective bargaining. And then I moved, a insertion that you had put in as the second part, of 28.1A, which deals with what happens if the university is required to make a change by law or by Board of Governors regulation. In which case, if that has a direct and substantial impact on workers' hours or any other term or condition of employment, then we will bargain the impact of such change in accordance with Article 24. And yeah, implementation may proceed prior to that. So, we're okay with that. In the, so yeah, I think you had also, 28B is, you had accepted, and we've also, accepted most of your insertions there. They're just kind of clarifying language. We did reject your deletion again of policy or with resolution, but I think the rest of it should do the same as before. As in your proposal.
I think I understand the conversation back and forth about policy. What about resolution though? Simply by definition, resolutions are normally just statements of opinion that normally don't have final impact. So how could a resolution have a substantial impact on wages, hours, when we can't push it in point?
Yeah, I mean, that's a good question. I think, yeah, this is again, something that I took from the faculty contract. And so, yeah, I mean, I think if it doesn't have any impact, then it wouldn't apply. Yeah, any other questions?
How do we see lines 14 through 16 lining up with lines 9 to 11? 14 through 16.
Right, so, these are basically two different cases, right? One is when you have to do it by law, and then the other case is when, oh yeah, sorry, and I should have explained. So another thing that I had, deleted was, the way you had written it was that if the university adopts a new regulation, then you would bargain, then you would enter into collective bargaining, whereas this is about if there's proposed a new regulation, which is also why
So you're giving them as two distinct cases. I just want to make sure
Yes,
that's
that's
okay.
And that's also why we reinstated 28.2, which is that we'd like to know when a proposed regulation might affect terms and conditions of employment. And I realize you said that you were already doing that or something at this point. So if you are, then in that case, I don't see any problem in leaving that in the contract, and if you're not, then we would definitely want to have that. And again, when it comes to 28.3, this is something that you had, deleted. But for us, it's important to have this in there. But we did again to try and have consistency with your insertion, which we've now put in 28.1A at the end. We've added something at the beginning here, which is saying that unless obligated by law for the Board of Governors regulation, no existing or amended regulation shall apply to bargaining unit members if it conflicts with the term of the agreement. Sorry, I should have pointed that out about the adoption.
That's okay.
So if we propose a new regulation, but the regulation doesn't get passed, and then, so we propose a new regulation, that means you have to impact bargaining. The new regulation is adopted.
Yeah.
Then we just cease impact bargaining.
Yeah. Would we would,
Okay,
yeah, there's gotta be a timeline where we would withhold ratification of the impact bargaining. Let's say we do it at lightning speed. Let's say we get together in one session, wrap it all up. And then the proposed regulation
it's not,
is down
it's not adopted.
and doesn't get passed.
Right.
We would need to be like, all right, so,
Well, it would still
We
have to be
wouldn't-
ratified. Both
Yeah.
sides, right?
right, but we would like, wait.
Yeah,
Because
I
there
mean, I
have been
think at that
times-
point, we just wouldn't put it up. for-
Right, yeah, I'm just thinking, sorry,
Yeah, we just,
we don't get over,
Yeah,
we can get over your skis.
yeah, we don't want that to happen.
Yeah, no, that-
Because then we could wind up agreeing to something by impact that wasn't necessarily
Didn't
impacted because
even-
the reg didn't pass.
Yeah.
And sometimes there have. been
That's why I
times when they-
that's why I put adopted there, yeah.
Well, there have been times when they proposed regulations that were proposed for a really, really long time before they were acted on.
Yeah.
Or they got changed. See, that's the other thing is sometimes they get amended too.
Yeah. Well,
So-
yeah, there's accounts for that.
that would be, yeah, we would do it again. With them and then.
Okay. You guys have more?
Yes.
All right.
So,
You guys came with a lot today.
23.
Thank you.
So, I didn't make any changes to 23.1 since the last time, so 23.2, okay, so there's basically these two lines in, basically lines 12 to 14. You had reinserted, I mean, that's current contract language, that I had deleted and you had reinserted and I deleted again. Because again, I feel like, it's too vague, it doesn't, it's again, something that's not in the faculty contract. And it's essentially saying that, you know, I mean, we're not obligated to bargain collectively on any subject matter that's covered by this agreement. I think that makes sense. Adding the phrase whether or not referred to, or even though such subject matter may or may not have within the knowledge of conservation of parties at the time of the agreement. I think that opens, you know, that leaves up so much things. Whereas the subject matter that's covered in the agreement is the subject matter that's covered in the agreement. That's very concrete, right? The other stuff is too vague, and I don't even see what the purpose of it is really. Like that.
Yeah, I mean, I think to some extent, it's an acknowledgement of the fact that we exist under a sort of a federalized system of laws, and regulations and responsibilities that, you know, we don't want to be getting into an argument with you all about whether or not, if something's not in here, it's almost like, not exactly like, but to some extent like a reserved power. In other words, if the contract doesn't contemplate something, then it's arguably going to be a reserved power management. You know, and if we don't contemplate it, there also may be changes in the law or changes in regulations that are contemplated that we wouldn't necessarily have to impact bargain if they don't make a substantive change to the agreement.
Well, so then we wouldn't impact our.
Right. And I think that's what, I think that, my interpretation, that's what that statement is saying. Look, there may be things that we haven't even thought of yet. Or we haven't even talked about that we may wind up doing. That's, I mean, you asked what the sort of where does that phrase come from? Where does that concept come from? I think that's where it comes from.
I'm still not understanding. So it's stuff we haven't thought of yet, but you're worried that it wouldn't be. Shall not be obligated to bargain with respect to any subject matter. I'm sorry, I'm
I'm
just
on
not,
13 and 14. I'm just talking about 13, 14.
right. And I'm reading the way that we have it written now with the strikes. I'm just not understanding what those words do. Like, if we adopted this language with the strikes, how would that situation be different than if we left in the language that we're trying to?
Again, I think it's an acknowledgement. I think it's an acknowledgement that we exist in an environment that there are, forces of authority legally above us that have the ability to make changes. I think that's what I think that's what it's from. That exact language has been in other contracts that I've dealt with before, and that was specifically what that was intended for. It's actually a pretty common, very close phrase is in a lot of contracts. I'm not saying we have to have it.
Yeah, no,
I'm just saying.
Is it-
I
not
wanted an
just us.
explanation.
Yeah.
So is it,
Yeah, go ahead.
sorry, I was just asking, so is it more about if, because you say, there's higher powers that, that can pass laws or different regulations that the university must follow? Or you're just saying that if those laws or regulations pass don't affect the contract that or doesn't it, or a contract doesn't have anything about like whatever the law or the regulation change, then we're not obligated to bargain it. Is that what that's saying? Like only if
Yeah,
the
it's not-
law or regulation affects the current contract as it stands right now, then we'd be obligated to bargain. Otherwise, not.
That's the standard. That's more the impact bargaining that we're just talking about. Like it has to have
Direct and substantial.
direct and
Right,
substantial.
exactly. So you're saying that these lines that are crossed out are just an acknowledgement of that fact?
Well, that fact, and neither of us is obligated to come to the table if one of us has an idea in the middle of the contract that, hey, there's this other thing that we really think we really have an obligation to talk about.
Okay.
Well, no,
I see.
the book is closed. The book is closed until we get the full book. We don't have to come talk to you about that. You don't have to come talk to us about it because you didn't bring it up. And even though you didn't know about it, and even though nobody had talked about it, nobody thought about it, we're not talking about it until the next.
Oh, I see,
I see
okay,
what you're
okay,
saying.
yeah,
Okay.
because if we crossed out this,
Then
then
this
only
subject
stuff
matter.
that is covered by the contract would you not be obligated to talk about. Bingo. That's what I was trying to ask, what's the difference
Yeah,
between
I'm
the
sorry
two
if I didn't
situations?
explain that necessarily very well, but, and again.
It's
the-
not, but maybe it'd be written.
It's not. But again, the reason I bring up the context is because it's different if we were existing in a vacuum and the only two things in that vacuum were JU and UF, and it was a closed system, you wouldn't necessarily need that, but having this phrasing of, look, stuff changes, there's other things that happen, it's not just us in this world together, kind of.
Sure. Okay, that changes my opinion. Okay. So,
By the way, that protects both of us, it's not just a protection for us,
No,
it's
no,
also
I
a protection
understand.
for you.
Yeah, for sure.
I literally just didn't see what it was.
I didn't understand.
It's
what it
weird.
is. Maybe we could rewrite it to like.
I
say that
wouldn't be
more
against,
clearly.
I
Yeah,
wouldn't
yeah,
necessarily be against that.
okay, yeah.
It's like the not, this is the wrong place. There's something about it that.
There's too many whether or not in the same.
It's a triple conditional negative,
Yeah. Who's the English?
I'll take a stab.
So, okay. Then, the second part of that, essentially, there's this one part where, you had you had deleted seeks to and, put in the phrase makes a direct and substantial.
Yeah.
And I think, the way I read that was and we didn't have the second sentence, I'll explain it in kind of together. So the way that you had originally read, we didn't have this last sentence at the end. So we just had the sentence at the top, and it would seem to imply that the university can unilaterally make changes to it. And then after the fact, part developing that. So basically in this sentence, we made it, if the university seeks to make a change to term and condition of employment, then the university is obligated to bargain the substance of it. Unless, which is what the last sentence addresses, if the university is obligated by law to make directions of change to a term of condition of employment, the university shall be obligated to bargain the impact of such change. And that, you know, we should do that. Yeah, whatever we request. And I think that has more consistency with that proposal with Article 8 as well, where we make an exception for, and you know, we take that point, like we understood where you're coming from the last time we talked about this, like, we get it, like, if you have to do it by law, then obviously you cannot simply go that. So, that's what we address.
My only comment is it seems a little repetitive on Article 28.
Yeah.
And if we just don't need it, it's essentially what Article 28 is.
Right,
It's the first sentence of Article
I
28.
do would be
that-
open to consolidating, but there is unique stuff in some of it.
Right, but this is a little bit repetitive of what's in here in terms of the obligation to bargain in terms of.
it is, but I mean, I feel like there's no conflict, then it does apply to both articles, right? I mean, in the sense that,
It also overlaps with 24.
Yeah.
yeah, that was gonna be my next.
Yeah, I'm just worried about having too much of it, like. Different.
Yeah.
Too much
You're
same,
about to
same,
hear
the
me
same
say
thing
this
in three
again.
different places, yeah.
So I think structurally, the purpose of Article 23 was to draw a hard black line around exactly what the terms and conditions
Yeah.
were defined as. And that was the purpose. I think we've now sort of, in this proposal, it kind of blends that definition with severability a little bit, and I
Yeah.
think it's a little confusing.
Well, if we go back to, I mean, this is the totality of agreement article, like almost every contract that
Yeah.
is written, just lease or whatever it is, is
Mhm.
gonna have a totality clause,
Sure.
which essentially just says like, this is the agreement. This is what you guys agreed to, and then like, even if like you thought about it, but you didn't bargain, like you didn't put it in the contract, then
Verbally
it's
said something, yeah.
it's not in it, and like, then it usually includes like a 23.3, the modification section.
Right.
So I kind of would encourage us to keep, like, to keep the totality language just.
Right, well, so I mean,
Without-
yeah.
What if we just do notwithstanding the limitations specified in Article 1? So we keep the severability stuff elsewhere. But obviously the totality kind of interfaces with it, so we could say. Notwithstanding the limitations specified elsewhere. As the end of that sentence, 23.3. Does that seem like that would help divide them back up?
Where would you put that, Jacob?
Line 15, notwithstanding these limitations, and then kind of restating the limitations. Line 15 could instead say notwithstanding the limitations detailed in Article 1.
Right, what would be the second half of the sentence there?
I don't know, I'm just trying to help you.
No, I know, but I just like, so
Sorry.
notwithstanding Article 24.
And 28.
Oh, okay, so notwithstanding is not working the way I was thinking it was. Make a statement at the end of 23.2 that says, no obligation to bargain in blah, 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 except when changing, making changes to the contract consistent with Article blank or something. You know what I'm saying? Like,
I understand. what you're saying.
separate out that portion and point them to the other article
Yeah, I
instead of
got it.
restating.
All right, we'll see if we can. Make something happen with that. I think I understand the intent.
And then, last one for today, 24.
We got 20 minutes left.
Amazing.
Did you guys bring 8? 7?
Something like that.
Wow.
Yeah.
A lot of them were easier.
Trying to show you that.
Those first ones.
That's okay. Yeah, I get it. Hey, I appreciate it.
Spring break next week.
I know. That was weird to talk about.
Yeah, I mean, I think these three articles are very much related, and
Yeah,
so.
they all
um,
work.
That's why I thought that's a good problem there.
We can use some format forward to strategize,
I think, no, we should, yeah.
strategize, who presents which articles. and just-
Sure, yeah.
So what are the changes, if any, that we should be focusing on?
So, yeah, sorry, sorry, presenting. So, okay. 24.1, we've left it, that's your insertion, we've, left it because we don't feel that it actually interferes with, 24.2. And I think our experience with Article 17, kind of, illustrates that as well. So, essentially what you had said is that, we enter into impact bargaining regardless whether it's subsequently enacted legislation is subject to lawsuit or, whether it's enforceable. For the, effect of passage law, you had actually deleted the first sentence, which is CCL, as well as the second sentence, which is our insertion. So we put those, back again. And, we also put back, the other insertion, which is, the last sentence there. And both of those sentences are basically taken from our last agreement on Article 17. Which, again, it covers all the possible scenarios, and we don't disagree that just because, something is being litigated, that doesn't mean we shouldn't impact bargain it, right? And that's what we did with Article 17 as well. But we do still want to leave in these provisions that say, if it's something contrary to law that becomes legal, or if something that has been subsequently rendered invalid, but that later gets involved with appeals, blah, 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 then that language takes it. And that would also, that's exactly what we came to an agreement on Article 17 in the end as well. So, that's kind of where I'm thinking with that, and that's why I said, I don't think that last sentence, that last phrase that you added in 24.1 actually conflicts with any of that.
Yeah, I think, what I would offer is that I don't necessarily think that which we're fine with, it's like lines 21 through 24. I don't necessarily think that is always consistent with lines 18 through 21. And the only reason I say that is because let's just say, for the sake of argument, that, the lawsuit on dues deduction, let's say it was successful.
Sure.
How do we practically walk that back from where we are? Like, I don't think we can just turn on a dime and instantly go back because we've already successfully impact bargained.
Yeah, but all the language about dues deduction is remains.
Right, what I'm saying is that depending on the way we impact bargain a particular item, it may not be like a heads or tails instantly reversible.
No, but I mean, that would afford us the ability to impact bargain in the way that we did last time, which is to say, hey, if this does get repealed or
Right.
struck down, then we can start doing this again. Okay.
Yeah, I mean, I
And-
think,
Yeah, go ahead.
no, you're good to finish.
And
You can
it's
finish.
talking engage in collective bargaining again with the intent of preserving the language. So it's not saying if it happens, it kicks back into effect for sure, like immediately.
Right.
then it's there.
Unless we bargain for that to happen.
Right.
Well, I'm specifically talking about the sentence that stands on its own, starting in line 18 and ending in line 20. If any provision of this agreement is rendered invalid by subsequent enacted legislation. Okay, so that's the first condition. So it's rendered invalid. That is later enjoined, repealed, struck down, or amended in such a way that permits the provision of enforcement. The language in the provision immediately takes effect.
Sure.
So what I'm saying is I just think there's situations where we can't necessarily make it happen that quickly because there may be some implementation considerations that we're gonna have to talk about. I don't think we can necessarily need to be like, oh, we stopped doing this because it was legally unenforceable or it was legally invalid. So we stopped, and this is how we gave you an opportunity to bargain the impact.
Right.
The impact brought us over here to this new reality. Oh, guess what? The thing that brought us to do the impact bargaining, now we can go back, do that. What do we do with the impact? Because maybe we identified something that went a different That's all I'm saying is it's not necessarily simple. That's my
Well, I mean,
point.
then whatever we impact bargain is the contract provisions at that time. So if those provisions don't have something in them that could go back into effect if the law is struck down, then it doesn't matter, right?
Right.
Then the situation doesn't apply.
I read that as like, we haven't even really concluded impact bargaining
Okay.
yet.
Right, exactly.
Yeah.
And then-
Yeah.
And that's a moot point, you know?
Right, I just think that
Or-
timing is probably, in many cases, if the lawsuits are drawn out, like if it is a lawsuit that winds up changing it. Typically, if it's an appreciable impact, if it's something that's significant, we're gonna try to get to the table and solve it quickly. We'll probably be done before the lawsuit's resolved.
Yeah, definitely.
You could enter some kind of like MOU or something to, I don't know,
And-
agree to, like, say we
Right.
had to put the dues deductions back in place and that would take like a couple.
Yeah,
Like a
give a
couple
grace
pay
period or
periods, and
something like
maybe
that,
you
yeah,
have like
sure.
an MOU.
Right.
I don't think we would be like opposed to that.
We would talk to you guys about it, but like I
Yeah.
said, sometimes it's not just as easy to back the train up. It was like, well,
No,
we went a completely different direction as a
Right.
result of the bargaining
That's
efforts.
understandable, yeah.
We can't just wave a wand and be like,
Yeah.
like just reverse it.
Yeah.
It doesn't necessarily happen that way.
Sure. No, I'm.
And we
Okay.
can, and when we do impact bargaining, we can include provisions, like if we feel that it can be like backtracked immediately, we can include that like with whatever when we amend the article during impact bargaining, saying like, if this is struck down, then this can immediately take effect if we feel like that's necessary at the time. So besides that, but yeah, I think, we agree that.
Yeah, I'm just thinking about, it would feel badly if we, if we felt we were forced to do something, we be in good faith, engage in impact bargaining, we reach an agreement, both sides ratify it. And then
Right.
we're in a position, you can't really back it up, and then you guys file a grievance and you're like, oh, you didn't reverse the language, we're like, wait a second. We came to the table, we tried to get through it, and you guys
Right.
ratified the agreement.
Well, yeah, and that's why I wanted to have this language in there, right? So that we have that latitude if we want, if that's like how we decide to deal with it, right?
I got it.
And if we don't want to deal with it in that way, then presumably we would also think about that eventuality.
All right. Okay, I get it.
And 24.3 is something you guys have crossed out entirely. The main comment that I heard from you guys last time was that you didn't want to cede to the idea that, it may be unconstitutional or not, or that we're allowed to litigate it. And you know what, we're fine with leaving that out, because whether or not you acknowledge that right, we have that right anyways, so we don't have to put it in the contract. But the first sentence is important for us to have, which is that we don't see the authority for either of us to invalidate, unilaterally.
So how does that square with how you view the BOG or the state legislature?
Well, that's not either party taking a unilateral decision to invalidate the contract, right? You're being obligated by law or bar.
Am I interpreting any party too broadly, Olivia? It doesn't say either party, it says any party. Or constitutional
Except
authorities,
it's
not.
set forth above.
Any party.
Except it's set forth
I
above.
don't know how we use party collective agreement in another term. I don't know. If it's fine.
Okay.
But I see what you're saying.
You see what I'm saying?
I see what you're saying.
So maybe instead of any party, we specify USU and the university.
Party citizen agreement.
Yeah.
Party-
Yeah, that would solve it from my perspective. I just don't want to get drawn into a constitutional argument about whether or not the Florida Constitution effectively empowered the BOG to make regulations about the operation of the person.
Sure, I think that we can leave that.
And I wouldn't bring it up, except that's been contemplated in court cases, so.
Right, okay.
GAs don't have time to argue that.
All
Yeah,
right,
so
thank
that's
you.
all we got.
Hey, that's not all.
That's all?
You guys came very prepared. I really appreciate it. You guys did a lot of work. And it looks like on a lot of this stuff.
I think at least the
think
first four that we presented were pretty close.
I mean, clearly we have some sticking points that we still have to work through, but I mean, there's a lot of stuff that we're getting pretty close on.
I agree.
There's some
Oh, yeah.
articles. we
Yes,
need-
exactly, yeah. Let's talk about that, yeah.
Yeah, we will.
Especially about 10 and 12, I think there's quite a bit of separation between us at the moment, so I think we need to get the back and forth started with that as soon as possible.
Okay.
And what was the other thing? Four?
I'm just trying to think of ones that other articles reference, or, you know, like the, we have to kind of make progress in one simultaneously with the other.
Like 4 and 5.
4 and 5.
I mean, 4 and 5 is really together. I think 7 can go with either, it could go with like Article 10. 7 and 10 is pretty good together.
I think
Or
4
Article
and 5
7
are
and
not
4, 5.
The only ones, when we started today, the only three that we had, I think were 3, 10, and 12. I think you guys had everything else,
I think it might.
except not this, I don't think either of us are proposing necessarily definitions article, that's like 20, like, I think that's the only one that neither of us has brought up yet.
And 17 technically, but I think.
Yeah, I think we're, yeah.
Okay, that's, anything else you wanna?
All right, do we want to work out any more talk
yeah.
on those wonders canceling? We were gonna do
Yeah, I
like.
need to write that.
Yeah, you said you just wanna exchange
email
emails
back
that
and
day?
forth?
Yeah, let's just, if, we feel that there are articles that are like close to being TA'd, then we, you know, it doesn't, you know, we don't need to explain it in email what's going on.
Let me talk to my team about that, and we'll get back to you. But next week we're not
I need
meeting,
to
correct?
Cancel that.
I don't think so.
Yes.
We're not meeting next week.
Yeah, no.
Yeah, we agreed to that.
Yeah,
we're
At the beginning. Okay. All right, thanks, guys.
All right, see you next time. Thank you, you too. Or I don't know, gotta be.
Well, yeah, that's something else. How about that?
Did I end the report on?
I can,
Oh, should we go give them the debrief?